Thank you very much, everybody, for being present, and thank you for the invited speakers for this to participate in this event. The news and the background of what is happening all around in Ukraine is, I believe, is very well known to everybody. This occasion is being used for us, for our colleagues who are all very well renowned experts on their field, to cover some of the most important issues which are related to the war going on between Russia and Ukraine, which unfortunately in this year's February has taken an open form of aggression, which has made the ongoing conflict situation even worse. It has made it an even worse situation than it has ever been before, while it has been going on since at least 2014, as you clearly understand it and we know about it. But this open aggression form of the use of armed violence in the territory of Ukraine has raised a lot of questions which are very important and related to international law, protection of victims of armed conflicts, protection of refugees, of civilians. And also at the same time, as we have prepared in our concept note to this event, it also poses a serious test to the European political and legal system, including the European Union itself. So this online event is basically addressing these issues, and as the result of that, we are going to try to find some conclusions about how this event could be, how does international law, how does the existing legal political institutions of international law are able to deal the situation, to help those in need, to try to lessen the tragedy of the use of violence currently going on, and then also how the European Union, how European actors could have an effect on doing something against it. That is the final question of the meeting of today. So I would like to call our first speaker to address the issue which was given to him by after negotiations, after talking to each and every speaker that you can see and hear today in this event. All of them have been assigned to a subject which is close to his or her research areas, and he or she is an expert of that. As you can see, we have a very nice international pool of experts representing all kinds of countries from the Central Eastern European region, from Estonia to Ukraine, of course, Romania, Poland, Hungary, and the Czech Republic as well, and Lithuania. So it's let me tell you that I'm very personally, I'm very happy and satisfied that these colleagues and friends have accepted our invitation. And I hope that our collaboration and cooperation is going to be fruitful in the future, and we are going to be able to do something with the collection of knowledge and experience that we will have, that we will demonstrate during this event. So as the first speaker, I would like to give the floor to Mr. Aleksandr Popov, who is representing the Estonian Military Academy, and the subject he is going to cover is going to be the problem of general respect towards international treaties, and the question how these international treaties and international law can possibly limit the use of force, if at all. So thank you very much, and Aleksandr, you have the floor, please.
Thank you very much, Tamás. Good evening. It's an honor to be here. First, let me start out with the sad reality that there is in the last 2 months, especially, been very interesting, to say the least, to talk to the people engaged in military and their daily lives, that there is such a thing as rules regarding the conduct of warfare. Yet at the same time, we do have to acknowledge that the treaty law is still there, at least for the time being, I guess, up until somebody decides to maybe, well, try and renegotiate it. Then, first thing I would like to say that I will not go specifically into treaty law as a problem. I guess the 3 issues I have on my mind and close to my heart is, first and foremost, whether there is reason to talk about treaty law from the point of view of general bindingness, secondly about how the treaty law would affect or ought to affect the conduct of warfare, and last but not the least, how much does it regulate the use of force? So when I was asked to speak and I was thinking about the treaties, then the first issue, well, from the one point of view of the treaty law in general, the idea of pacta sunt servanda, well, still is present, not just in the Vienna Convention on the Law of Treaties, but also in the case law of International Court of Justice, among other things. Yet, of course, at the same time, if we take the example of the by now infamous 1994 agreements, which, among other things, included countries like France and Germany and Ukraine, that promised Ukraine certain support, to say the least, in case of its giving up on things like nuclear weapons in order to make itself, as one might say, more acceptable as a partner to former Union of Soviet Socialist republics. That sadly, in practice, what we can see now is that Ukraine was hoping on pacta sunt servanda, but as a country, they now have to live with the reality that pacta, well, sometimes sunt servanda, up until the time that this living up to the agreement is useful. As mentioned previously, we talk about discussions undertaken by political leaders. Then on the one hand, President of France calling Russian president every day might be a very good idea. I mean, I hope he will get, if nothing else, then the award of the most persistent caller of the year, because there are very few leaders in the world that would put up with so much hassle like this for one day. Yet at the same time, the memorandum is still there. And the question, of course, to be asked is how much and in what form can we encourage not just Ukraine, but other member states of that agreement to enforce it. And on the one hand, you could say in a less dangerous times that we could rely on the judicial mechanism, something that Ukraine is doing at the moment in the International Court of Justice, being supported by other member states of the UN in regards to the issue of the so-called genocide happening on the territory of Ukraine, which some countries have recognized the actions of the army of the Russian Federation as tantamount to the crime of genocide. How much evidence of that, for example, is going to end up in the International Criminal Court yet remains to be seen. We do have investigation ongoing. At the same time, of course, we have the debate over whether or not we should once again create the new tribunal to deal with the new atrocity. In my humble opinion, we have plenty. What we should think about is trying to, first and foremost, of course, get the aggressive party to end the violence and go back, at least get back to the table of negotiations. In that sense, treaty mechanisms are there to hold the states responsible. But of course, in practice, the question here is whether or not there are states willing to address those treaty mechanisms and do anything and everything in their power to actually create the mechanism of responsibility. As to my second point, and the law of armed conflict more specifically, which happens to be one of the most regulated or one most technical treaty mechanisms in the world, if we look at the both Hague and Geneva law combined, then from the perspective of application of treaties to violence, the rule book that has been in existence for 150 years is there. Now, the practical question, of course, is that how much of it has been respected. We have different examples. We have mass atrocities created and perpetrated by the Russian army. Well, sadly, the current most heinous example would be Bucha, as much as we have gathered evidence about that. At the same time, there are those who try to use the mechanism, obviously the Russian Federation itself, against the Ukrainian armed forces and defense forces, or even the volunteer battalions, claiming that the acts undertaken by those defending Ukraine are in violation of the treaty mechanism. This is something to be analyzed and looked at from the point of view of facts, not mere supposition or suggestion, but the reality of life is that the law of one country does allow for reprisals, among other things, if the law is as such violated against you. Of course, in the situation of the current aggression, full-scale war, one country against another, obviously one of the questions to be asked is that how much do people who fight for their survival ought to be aware of the existence of mechanisms? Of course, there are those in the army of Ukraine who know the law, such as people also in the army of the Russian Federation. But at the same time, at least to me, the main difference in this conflict is that on the one side, there is a nation that just tries to survive. Yet on the other side, we have escalating armed activity determined to, well, as much as I understand it, of eliminating a nation as a whole. Well, to bring out the example from International Court of Justice, one of the advisory opinions I've never really understood. Then again, sadly, in this situation, we could have an example would be the nuclear case advisory opinion, where the idea of sort of alleged use of nuclear weapons in case of having the nation as a whole being threatened to survival was used by the court. Not a very good example, because of course in practice brings around how would you describe such a possibility, but in the light of what the president of Russian Federation and other high-standing officials have said and are saying about, among other things, the reasons for war, or what they call special military operation. In my humble opinion, any military operation is special by its nature. If you don't plan it, then what's the point of having it to begin with? But using different terminology at the end of the day, in the eyes of the treaty law and the interpretation of the treaties, does not change the fact that something can be interpreted as war in the eyes of the existing treaty mechanism, then, well, for those who do interpret it as war, it is war, even if the other party would call it anything else. And again, after the fact, the evaluation is something that remains to be seen. As to the use of force, well, two practical sad realities. Number one, one of the parties to the conflict is a permanent member of United Nations Security Council, which kind of takes the gist out of the hope for United Nations Security Council doing what it's supposed to be doing. And not, one might say, not because they don't want to, but the reality of life is that as long as the P5 has a veto power, the technical aspect is on the side of the region. Though I still do love the argument by the Ukrainian representative in the UN, by the reference of the reality of fact that Russian Federation is not actually a member state of the United Nations Security Council, because if we read the United Nations Charter, no Russian Federation there, it's the Union of Soviet Socialist Republics. So in practice, of course, at the moment, it's an argument that might not bring about too much resolve. So it's always good to point out the history, and I'm sure it made a dent in the armor of the representative of Russian Federation to the UN. And the second issue with the threat of force. There is no threat of force to talk about. There's war ongoing. We're way past the level of whether or not that we should consider self-defense. What we are facing now is that the question of what can be done to contain the situation and create the possibility for Ukraine to defend itself. In my opinion, two things that ought to be happening quickly. Ukraine needs weapons that they gave up back in the day to protect itself. You cannot just send hopes and prayers. That might work on social media, does not work in real life. And secondly, the main question still is how much other member states of the United Nations or any other regional or international organization that is interested in creating the peace and stability in the world would actually be willing to sacrifice, especially politically, to support Ukraine in their struggles. On the one hand, there's a lot of regional politics going on. At the same time, we are being escalating to the problem of world famine, among other things, facing us in the near future if the grain that's usually been exported by Ukraine to other countries keeps on being stolen by the other state or simply blown up. So the question here for the United Nations, among other things, is that whether or not there is a mechanism, something similar to, well, I guess coalition of the willing would be one of the best examples from modern history, let's put it this way, where the reality of Security Council as a mechanism facing tough decisions which they were very unhappy to make or unable to make because of a technicality was, well, I wouldn't say superseded by, but merely overcome by political will of certain group of member states who decided to sort of face the music of potentially being called upon or in front of the Security Council. But then again, at the same time, there as well, one of the parties to that particular coalition was a permanent member. So here it's more about the will of enforcing the treaties, of doing anything and everything in our power to just convince the political leaders who have the power to make the decision, but also to provide them with best potential analysis of what is the outcome, what should we do, why should we do it right now, and what will it cost the treaty mechanisms as such. Because in practice, treaties are residual mechanisms. To bring an analogy from contract law from any nation states, yes, it's good to have a contract, but any solid businessman knows that the contract will help you as long as the other party is willing to uphold it. If it doesn't, then we're back to using the existing legal mechanisms to try and make them to, well, live up to their part of the bargain. At the moment, sadly, of course, I personally am not seeing, at least now without the regime change, the current leader or dictator, I guess would be a good term, of the Russian Federation, of stopping what he started. I mean, to me, it's not about whether or not he's going to feel embarrassed or not. The man in his speech rather openly stipulated that, in his opinion, the country he's fighting against, or the nation he's fighting against, does not exist. So it's, I guess it's a tough fought to overturn. But what the success of Ukraine as a nation and its military forces has shown is that it is an enemy that the Russian Federation was not expecting. And this war is gonna end mildly different from what certain generals back in Kremlin were perceiving. And in the end, it's about us, the nations, giving support to Ukraine to the best of our abilities in order to not just uphold the treaty regimes in existence, but to actually show to the world that treaties mean something more than ideas put down on the paper. Thank you.
Thank you very much for these initial thoughts, which served very nicely as an introduction to go to further subjects. And basically, when talking about adherence to already existing international treaties and provisions of law, the next subject by Agnieszka from the University of Warsaw, I believe that has something to do with that issue. Agnieszka's subject is going to be about the refugee situation related to the current war, with a special attention paid to the current Polish experience. So Agnieszka, thank you very much once again for coming, and you have the floor, please.
Thank you very much. It's my pleasure to be here with you and to have the opportunity to discuss with you all those issues. I will be focused on the question of refugees in Poland. But of course, I'm open to any questions concerning the war in Ukraine and all humanitarian issues. So I remember in 2015, there was the information from the United Nations that the number of refugees in the world reached the number from the Second World War. And I was so shocked. It was like 50 million. And today it's more than 100 million. And of course, we have never expected that a huge number of refugees also will somehow influence the Polish situation. But after, even before the war started in Ukraine, the government expected that, of course, the Polish-Ukrainian border will be this place where we can see this phenomena. And at the beginning of February, the government started to prepare Poland for that in this way, that asked local governments to prepare the shelter, volunteers to host refugees in case of the war. But of course, when the war started, first days were very chaotic because like Poland was not an experienced country, to be honest, with a big number of refugees. And imagine that, for example, only in Warsaw, in Warsaw railway stations, we had like 30,000 people every day coming, and people just saw that on TV, and many of them decided to help. And first days or even weeks of that reaction, it was like a huge civil society action to support our dear friends from Ukraine here in Poland. So many people just went to the border, and really everybody I know tried to do something. A lot of people. Of course, what was very important, that in Poland there was around 1.2 Ukrainians. So when the war started, they were able to be engaged, they were able to help, they were able to open day apartments for people from Ukraine, as facilities in Poland was not prepared for such a huge number. And like nowadays, today, according to the United Nations, 3.8 million people from Ukraine crossed the border, and more than around 1.1 million are registered. Probably the next million of people are not registered, and 1.5 million Ukrainians decided to come back to Ukraine. So, for example, currently, around 20,000 Ukrainians cross the border from Ukraine to Poland, and 26,000 of Ukrainians cross the border from Poland to Ukraine. So that is something what we observe. But according to the United Nations, of course, depending on the situation in Ukraine, we can expect additional million of refugees in Poland from Ukraine. But of course, it's just an assessment. We are not sure. So at the beginning of the war, the government announced that everybody will be welcomed in Poland, and even without any documents. So and that was true, that Ukrainians and Poles at the border, they of course accepted people also without documents. And what was also important, that Polish government and also European Union issued directives, laws that like providing temporary legal status to people from Ukraine, because of course Poland is a party to Geneva Convention on refugee status, but not so many Ukrainians try to want to use this way, because very often they don't fulfill criteria. As you know, the situation of wartime is not enough criteria to get the status. And all those who decide to apply for the status, they cannot work for half a year. So they prefer to use another option. And that another option is that refugees from Ukraine who are registered, so they have the right to have an ID number, like in Polish PESEL. And if you have PESEL, you can get social financial support. You can use the healthcare system, and you can use also education system. So like ID number gives you quite many opportunities. Of course, it doesn't mean that if you as a refugee from Ukraine didn't decide to register yourself, you are not supported financially by the government. There are some opportunities, financial opportunities. But ID number also gives you an opportunity to get additional funds for every child. And most of people, of course, who crossed the border with Poland were mothers, women, mothers with children very often. So it is important for them. And it was also amazing to observe in Poland during this first weeks, also nowadays, volunteers from other countries who decided to come to Poland, who appeared at the border in major cities. And they also are involved in providing assistance. And some organizations, I mean, International Committee of the Red Cross, but of course ICRC is rather focused on Ukraine. And in Poland there is also a headquarters of UNHCR, and UNHCR pays some funds. It's around 180 euros per month. You can get those money for it's like for 3 months. So it's not huge, a lot of money. It's like a temporary solution, to be honest. And the problem with UNHCR funds is that there are only 2 offices in the biggest cities in Warsaw, and you are not able to get this money like using electronic way. You have to stay in queues. So taking into account that there are, so many mothers with young children, very often it's problematic for them to stand, to wait for those money, etc., etc. So we assess that around 20% of refugees are in, let's say, Polish houses, that quite many Polish families decided to open the apartments, houses, flats for Ukrainians. We, like everybody of us, we had also quite strong relations with Ukrainians. So it was not difficult for us to offer some help, to be honest. Most of and around 70% of Ukrainians, they are quite independent, or they stay in apartments with their Ukrainian friends. But of course, there are some vulnerable groups. So, for example, mothers with very small children, it's very difficult for them, for example, to find a job. It is assessed that around 200,000 of Ukrainians found the job in Poland. So let me say what are maybe challenges, because of course like local governments and civil society's reaction was very good, but we are in Poland aware of challenges which we face. And first of all, there are a lot of structural problems which haven't been resolved so far. So I mean availability of apartments, like rental prices in Poland are very unstable right now. And And still there are some, in some cities, because many refugees, they prefer to stay in big cities. So, for example, in Krakow, around 25% of inhabitants are refugees from Ukraine. Like in Rzeszów, Przemyśl, quite big percentage of inhabitants are Ukrainian. In Warsaw, it is around 13%. But most of them, they would like to stay in Warsaw because of labor market. But taking into account that, you know, the government thinking rather is that they provide financial support for around 3 months for refugees and for families which decided to host refugees. The idea is that refugees should somehow adapt. There is, of course, the language barrier, but even yesterday, you know, representative of the government announced that there is a lack of money, and that of course we should. Poland got support, among others, from the United States, from the European Union, from Japan, for refugees. So that's very helpful. But in long term, you know, to ensure apartments, to ensure education, healthcare system, etc., of course, quite big funds are needed here. So among those challenges which we are afraid is homelessness. Like fortunately, there are less and less big halls, market halls, where refugees stay. So there is still some facilities, you know, ready to host people, but people prefer to stay in apartments in long term. So that's obvious, that those solutions are only temporary. So we expect, we hope that the government will have like more systematic approach to the question. Then there is a challenge of vulnerable groups, as I mentioned, mothers with young children, and people with disability, elderly people. And for those groups, the government announced that they will be supported all the time, also financially. Then what we would like to have, it is support for social workers and volunteers. I am also involved in some actions, and I can say that there are a lot of people who provide volunteer support, but we also observe that they are tired, that they you know, have other duties as well. So so there is a need of like a stable support from the government. The challenge also is what we observe to avoid, to prevent slavery, because the police gets the information from time to time about the situation that, for example, somebody offers the bed, the house, instead of labor. So there is this challenge, right? Human trafficking as well. It was especially like first weeks of the war. There were some NGOs which were involved in on the border, which provided leaflets warning women, but and also I was like, it was like a very positive for me when I also provided some humanitarian aid, and when I wanted, for example, to transport some refugees from the border or from Przemyśl to Warsaw or to Lublin, like they checked me, they took the photo of me, so everything was transparent. But I know that it was not a rule, and like there was a need to, you know, for some time to adapt to the situation. Then let me say a few words about schools. right now around 10% of Ukrainian children go to Polish schools. And it is, of course, the challenge in terms of the language, in terms of the culture. We are aware that more free language courses are needed. Some Ukrainian children, they have online teaching, but I'm not sure if Poland is able to control if there are no children which are excluded from educational system. I'm afraid there is not enough control for that. Nowadays, many NGOs try to organize holiday activities for Ukrainian children in cities, outside cities, but still it's not enough what we observe. The challenge also is discrimination of some groups, especially Roma people, which are not so welcomed in people's houses, but also Russians and Belarusians, taking into account the context of the war. And the challenge also is huge disinformation. There are more and more reports about the disinformation which you observe in the internet, inspired probably by Russia, trying to influence people's emotions and put Poles and Ukrainians in contradiction. So we also need to work on that. And of course, I can summarize that it's a huge challenge, but we all the time repeat to ourselves that it is a privilege to help, and it's like an important exam for Poles from the solidarity. Thank you very much.
Thank you very much, and thank you very much for drawing our attention to the importance of NGOs and non-government and the non-government sector, which I believe that very similarly to the situation in Poland and Hungary has also been shown how important, to some extent, I believe you could say that it was inevitable in handling the situation as it was. So now let's go to another subject, which is also a very important and very interesting issue here. Now we have seen, hopefully Justinas is going to cover an issue that usually as international lawyers we maybe do not pay too much or enough attention to, that is the applicability of domestic law when it comes to responsibility for international crimes. According to our previous conversations, he is going to cover the question of the first Ukrainian criminal trials for captured Russian soldiers for possible war crimes. So please, Justinas, you have the floor.
Thank you, Tamás, very much for the inviting to speak in this event. And also, I would like again to say hello to all the colleagues. It's a pleasure to see those old and new. So I just would like to a little bit to adjust my topic. I will speak indeed about the Ukrainian Criminal Code and the regulation of war crimes and other crimes there. But in fact, I would not speak very much about the trial itself, because in a way it's quite clear-cut situation there. But looking at the Ukrainian Criminal Code, there are more issues to cover, especially having in mind of all the trials that are supposed to come, I guess, because anyway, these first, if I'm not mistaken, now 3 trials, from which one is finished, but still will be perhaps an appellate procedure. So it's still a long way. So I would like to take a little bit more general look at the Criminal Code of Ukraine and to comment a little bit on the issues, how it is structured and how it can be used, or maybe sometimes which problems it could we could witness while dealing with it. So now I'll try to share a very short presentation. I will not take very much time. So, host disabled participant screen sharing. So, okay, so then I'll speak without sharing a screen. Okay, so first of all, I would like to remind this simple issue that under international law, including Geneva Conventions on the Customs and Laws of War, like was mentioned by Aleksandr, and all the other treaties, the initial and primary jurisdiction for war crimes rests on the national states. Moreover, it's not just a resting jurisdiction, it's an obligation. It's an obligation of every country to watch over its own military forces and any military forces that are present, in order to guarantee that the behavior in war is according to the law. Therefore, Ukraine, and in this case Russia as well, they both have national jurisdiction in this situation. What is more even important, that because we are having international armed conflict here under the, let's say, international humanitarian law, any basically state to which, let's say, participants in this conflict, whether it would be combatants or, let's say, any other persons, are traveling, if they committed a war crime, they could be prosecuted also in any national jurisdiction.
Sorry for interrupting.
Yes.
I have just, in the meantime, I have adjusted the settings, so you should be able to share the screen now. I'm very sorry.
Okay. Oh, it's okay. Okay, I'll try that my best. Yeah, where it. Sorry. It's just a moment. Okay, so but these are the things that we as international law specialists, and some of us are dealing in ICL, in IHL, we know all these things. And it was in particular interesting for me to look at the Criminal Code of Ukraine, though I'm not sure how to translate it correctly into English, whether it's Penal Code or Criminal Code. But anyway, we have document that is dealing with the criminal responsibility in many issues, including for the international crimes and the war crimes. So if to look at the code from very general point of view, so these crimes are put into chapter 20 of Criminal Code of Ukraine, and in this chapter we see a variety of crimes. Some of them are more or less related to or could be related to the ongoing war. Some of them are of different character. So if, you see on the slide that here we have propaganda of war. That is not exactly a war crime, but still international crime. There are so-called crimes of denial. So these crimes are related to the such crimes of denial of totalitarian regimes like Soviet Union, Stalinism, or Hitlerism, or Nazist ideology. Also, Ukraine has a special article on the denial of Russian aggression. That is totally understandable, having in mind that Russia is committing aggression since 2014. There is an article on war crimes, and this article was applied in those court proceedings that we just witnessed. Also, there are 2 articles on weapons of mass destruction. The usage of such weapons luckily haven't happened yet, and hopefully will not happen, as well as procurement, transportation, and all the general issues. There is a crime on ecocide, and as far as I remember from the at least media, Ukraine was discussing whether ecocide crime could be used, having in mind that Russian forces attacked 2 nuclear power stations. First of all, they captured Chernobyl, and then the power station of Zaporizhzhia was also under attack. It was also shot at, artillery barrage, and so on. Of course, there is a crime of genocide included. And that was quite a surprise for me that Ukraine is treating genocide in a very, let's say, traditional way. It haven't been touched by the, let's say, those tendencies that genocide extended to social groups or political groups. It's just a classic genocide following the Convention of 1948. And then we have acts against internationally protected persons like diplomats and head of states, then protection of emblems of International Committee of Red Cross, piracy, and mercenarism. So basically, to our situation, to the war against Ukraine, perhaps most interesting articles now is war crimes and genocide, but about the genocide, Evhen, as far as I know, will talk. So I will not dwell on it, and I'll try to look at the war crimes article. So again, if you will take a look at this article, you will see that it is quite a short article. It's some of inhumane acts are listed, like ill treatment of prisoners of war, civilians, looting of national, I guess, treasures from occupied territories, use of means of warfare prohibited by international law, and other violations of law provided for international treaties ratified by Verkhovna Rada, so it's Ukrainian parliament. And for such acts, a person can face up to imprisonment to 12 years. And if these acts resulted in murder, then life in prison. And this first guy who was sentenced under this article, so Sergeant Chichmarkin, he was exactly prosecuted and sentenced following this because he killed civilian. He killed civilian after order from his commander, and the situation was very much straightforward. And perhaps that was the reason why this process was not even very much discussed. First of all, the let's say circumstances were quite clear. Second, the defendant acknowledged his guilt. So question was only the, let's say, matter of punishment, which I think will be much more highly debatable during appellate stage, because as we know, there were much more heinous crimes committed by Russian forces in Ukraine. So, so indeed, there are still to follow. There are two more processes going on regarding the shelling of civilian objects, again, tactic beloved by Russian forces, and if I'm not mistaken, pilot who was bombing civilian objects. So, but coming back to the article 438, as far as I see from it, and as far as I look from it, I see that this article has been formulated long time ago. And it do remind me of the articles that were in Soviet criminal codes. And I remember the Lithuanian criminal code that was used during Soviet times. So in these articles, the crimes of war or war crimes were defined in a very general matter, in a very narrow state. So on the one hand, of course, to have a general definitions is good, because then you have a possibility to apply it to specific circumstances, even though quite often national judges are not very well versed in international law. And when you have such terms as prisoners of war, or let's say forced labor, or let's say prohibited attacks and things like that, these are definitely terms of international law. And the content can be seen only from international treaties. On the other hand, I see problems with this article, which I would like to list and to present for you, maybe for the further discussion. First of all, the scope is really very limited. For example, deportation of civilians should be a crime in itself. But here in this article, we have deportation of civilians for forced labor. So let's say if you deport just civilians, like let's say Tamás in the beginning said 200,000 children deported, or let's say all these forced deportations from Mariupol, from Berdyansk, from many other places. So then we have somehow to consider it as mistreatment of civilians and so on. So that would be problematic. Moreover, nowadays, most of European criminal codes, national criminal codes, are intended to be put in line with the Rome Statute. Ukraine is not a party to the Rome Statute. This is another issue that worries me quite a bit, even though Ukraine has recognized its jurisdiction ad hoc. But still, let's say if there would be cooperation issues with the Rome Statute, it's a question how with this article there would be possibilities to use Rome Statute criteria. Then in the article it is also mentioned that these crimes must be provided in the treaties recognized or ratified by Verkhovna Rada of Ukraine. And here's a question from my side: does, in that case, treaties encompass customary law? Okay, I know that we can make a link. Of course, we can say that, let's say that Ukraine is recognizing United Nations Charter, which provides for customary law and so on, but that's a long way to go. So in this case, when we don't have these ordinary actually expressed in the International Committee of the Red Cross Customary Law Study division between, let's say, Geneva grave breaches of Geneva and customary war crimes, that also might be problematic. Then the article is silent about international and non-international conflict. It's okay for today. For today's war, there is no question that's a war that's international armed conflict, a classic international armed conflict. But still, let's say for the modern state, non-international armed conflict issues, especially, for example, having in mind if, let's say, Ukraine catch a Wagner mercenary who was fighting in Syria. So he was fighting in Syria and he was fighting in Ukraine. So, okay, so it can prosecute for Ukraine, it cannot prosecute for Syria, and in Syria crimes were also committed terrible. And perhaps the most complicated issue in this article is that it is provided just ordinary forms of participation. It's either execution of the crime or ordering the crime. But what about common responsibility? And especially in this conflict, an issue of common responsibility is very important. Having in mind all these changing generals, having in mind Putin himself. So not having common responsibility clauses, and again, colleagues, I don't know whether all of you are well acquainted with the common responsibility doctrine, but common responsibility doctrine does not mean that someone gave an order. Common responsibility doctrine means that someone did not took due care of the military forces' behavior. So basically, it's a crime for commanders, or criminal responsibility form for commanders who are not watching over its military forces. Having in mind that in Russian military forces, a commission of the crime is considered as a normal policy. Let's say if we take, for example, that Bucha, that those military units that were in Bucha after were decorated, even though they were engaged in the crimes. That's exactly the issue where common responsibility comes into play. So that this thing that is missing in the code, I think it might cause problems with the Ukrainian prosecutions. So basically, this article could be used for the prosecution of ordinary war crimes, but it might be problematic in more complicated circumstances, and let's say especially, or maybe especially in the case of common responsibility. So it's for us to see how the things will develop, how the procedures of criminal prosecution will go on in Ukraine. But my honest proposition would be that Ukraine should take care of its criminal code and to make it in line with the contemporary regulation of the war crimes. Rome Statute perhaps is the best example, because I still think that sooner or later Ukraine will become a full member of the Rome Statute. And these legal uncertainties, especially having in mind that in criminal law, in international criminal law, nullum crimen sine lege is one of the main things, and afterwards it can be debated even in European Court of Human Rights. If anyone remembers, let's say, cases related to the Baltic state like Kononov, or let's say Vasilauskas or Žilinskas. So I think there's still a lot to do with this article. Okay, so that's all from me, and Ukraina переможе, I do hope.
Thank you very much. Would you mind stopping the screen share, please? Okay. So thank you very much for your presentation. Basically, talking about domestic law and especially criminal legal provisions, implementing IHL into domestic law, I believe that's one of the weak points that many countries can report about. Like we have been talking about, it is related to Hungarian law, for example, the implementation of international humanitarian law into the criminal codes of other countries is also a very challenging, very challenging issue. Unfortunately, it's especially unfortunate when we have to see this problem live, related to an actual situation. But this is a job that needs to be done, I believe, while preparing for the situations which we hope will never happen. Okay, thank you very much. And I would like to give the floor to Milan, who is going to give us an overview about possible future international fora that can be brought into the question, not necessarily with this conflict, but maybe they should be. So I'll give the floor to Milan from Prague, and thank you very much for accepting our invitation. You have the floor, please.
Thank you, Tamás. First of all, I would like to thank you for inviting me to this occasion. So I'm really grateful. And as you said, I would like to look at the question that, as you said, and correctly, is not just a matter of this current situation, but it must be kept in mind that it has been raised particularly in the last few weeks. So I am going to talk about rather theoretical aspects of the fora, as you said, regarding the crime of aggression. So not really necessarily connected with this current situation, but it is a very important topic in general, in my opinion. That's why the question was, or topic of the presentation was, ad hoc tribunal for the crime of aggression, a good or bad idea? So let me share the screen so you also see my PowerPoint presentation. Can you see it? Yeah, okay. So the reason for those discussions is that famously the International Criminal Court has jurisdiction, ratione materia, over the crime of aggression, however, in a very limited scope. And that was the basic reason why the discussions that have been suggested in the last few weeks, particularly, it has been discussed before too, but not with such intention. Sorry, that was the reason for those discussions, for an existence of an ad hoc tribunal. And those discussions have both created negative as well as positive as well as negative reactions for various reasons. That's why I'm asking whether a good or a bad idea. And the pathways of accountability that you can see here, obviously, the Rome Statute of the ICC itself, which I will, however, tell you why it's very narrow in short time. I guess most of you know it, but just to make a little overview. Then obviously another pathway for prosecution of any crime, no matter whether it's crime of aggression or any other international crime, is of course domestic prosecution. That is quite possible too. Once again, it has its advantages as well as problems rather than disadvantages. And the third possible path is, well, it's the third path, but it does not include one category, are the ad hoc tribunals. But the ad hoc tribunals can clearly be of various kinds. It can be an international ad hoc tribunal. It can be a hybrid tribunal. So it is not one path. So I put it in one kind of category, but it must be kept in mind that it's not universally the same thing. But I will go through it independently. So first of all, the Rome Statute, and sorry for being quick in that regard, but it's 15 minutes and it's quite a lot. So that's not a critical remark regarding the time. 15 minutes is normal. Okay, so Rome Statute. That was a historical remark that the crime of aggression was put into the ratione materia jurisdiction of the court. It was never before that a universal court of an international character had it in its jurisdiction. So in 1998, we could celebrate, but at the same time, it was kind of so-so celebration. The reason was that the crime of aggression was one of those, not the only, but one of those reasons that the negotiations almost collapsed. And in the end, there was a compromise between the states supporting the inclusion and those against it, that they would include it into Article 5, but not define it yet. And that's why you can see the second paragraph, which is not there anymore for many states, but not all state parties, saying that though it is within the jurisdiction of the ICC, the court will only be able to exercise the jurisdiction once it's defined, which happened in 2010 in Kampala and was activated in 2017/2018. However, and there is a however. The reason for that, however, are particularly in Articles 121 and 15 bis. 15 bis because it is part of the amendments that were agreed upon in Kampala. And virtually both those articles say very similar thing, just in relation to a little different pool of states. And the basis is that the attitude towards jurisdiction from territorial and personal scope is the other way around than it is in relation to the first three crimes: genocide, crimes against humanity, and war crimes. In that regard, in their relation, it is satisfactory if at least one of the following requirements is fulfilled: that the alleged perpetrator is a national of a state party, or, and that's important, or the crime occurred within territory of a state party. So only one needs to be fulfilled. In Articles 121, Section 5, second sentence, and Article 15 bis, paragraph 5, actually change that or into and, meaning that in Article 121, in relation to states that are not parties to the Rome Statute, that are parties to the Rome Statute but not to the amendment, and in Article 15 bis in relation to completely non-state parties to the Rome Statute. So it basically means that for the court to be able to exercise jurisdiction right now, both the aggressive state and the victim state needs to be both members to the Rome Statute as well as the amendment. And if only one of them is not, then the court does not have jurisdiction. Of course, disregarding the triggering mechanism by the United Nations Security Council. If I tell you the list of countries that are both state parties to the Rome Statute and the amendment on the crime of aggression, then you can imagine how likely there is, well, kind of fortunately, how likely there is that the court would exercise the jurisdiction. Czech Republic, Liechtenstein, I believe, Netherlands, New Zealand. So to say, fortunately, there is no chance for the courts now to exercise the jurisdiction because those states would not very likely attack each other. But the rest of the world is not in such a lucky position. So that's the reason why, very short, and I have skipped so many topics. So that's the reason why the ad hoc tribunal is actually being discussed. And as I said, the alternative pathways actually include a lot of ways. One of them, which I didn't include in the introduction, was amendment of the Rome Statute itself. And as I asked myself, is it worth, and directly answer yes. But there is a but to it. Once again, the amendment of the Rome Statute is a very, not really complicated, but politically complicated thing. And if we would like to change anything else, then Articles 5, 6, 7, or 8, the ones that define the crimes, it would need 7/8 of state parties to agree to it, and then it would enter into force for all of them. Well, that would, and scope of jurisdiction is a matter not covered by Articles 5 to 8. So of course it would be required to 7/8 of the state parties to accept that and ratify that. And that would take a while. Still doesn't mean that we shouldn't try. I think we should. So that's why, is it worth? Yes, but it will take a while. So something else could be discussed. And that's obviously the domestic prosecutions, which could be divided into prosecution both in the state of the accused, as well as in the victim state of the aggression. As long as in any aggressive state, as long as the regime is the same, it's very unlikely that it would prosecute its own point. Nonetheless, from the perspective of international law, it would not be a problem, of course, if human rights such as fair trial requirements were kept. So more interesting is the victim state of aggression, either based on own law or which we can discuss which states have it, but also universal jurisdiction. There is a problem, however, and that is the mentioned decision of the judgment of the International Court of Justice in the arrest warrant, which is quite famous for what it said. It was a matter of, I guess many of you know, of an attempt to arrest, or actually of issuing an arrest warrant against another state sitting Minister of Foreign Affairs. And the court famously said that the immunities, even for what is being alleged to have been crimes under international law, actually prevail over foreign domestic criminal jurisdictions. So that would be, of course, problem, these personal immunities. If any attempt of a victim state of aggression tried to prosecute anybody endowed with personal immunities. That would, of course, be different once those individuals would leave their office, because then they would have functional immunities. And functional immunities, it's not a 100% accepted opinion, but I agree with those claiming that it does get set aside, the functional immunities, for prosecution even in front of domestic courts when crimes under international law are involved. So that would be a matter. But once again, that's something that, you know, requires more than it requires more than just law. It requires the activity in the states themselves. So it's not that easy. So domestic prosecutions, that's it. Theoretically possible, but of course with problems. And because I mentioned the ICJ judgment, the ICJ judgment, among others, said that the immunities do get set aside in front of an international tribunal, but it was not very particular in defining what it meant by international tribunal. It just said that examples of it are IC2Y, clearly, because that's been created by the United Nations Security Council, or the Rome Statutes ICC. But interestingly, it said so about the ICC at the time when it wasn't even in force yet, meaning that there were less than 60 state parties, 60 if I, correct me if I'm wrong, but I believe it was 60 state parties that it needed to be, that needed ratification to enter into force. And that's why, was it international? Because it was created by an international treaty. And if that is so, what if two states create an international tribunal by an international treaty? Does it mean that immunities, even ratione personae, are not applicable in front of such a tribunal? I don't think so. So the court was not really particular in that regard. And that applies to my next question, agreement between other states. Well, it would have to be the international tribunal. We're not exactly clear what that means. Exactly, if it was obviously 100 and something states, like for example the ICC, the same amount of state parties that the ICC now has, yes. But who knows whether that would be possible, because apart from the immunities, another problem would of course be whether it would, how it would be financed. For example, because even the ICC doesn't have really the best situation in that regard. In any way, if only a few states did that, there would be a matter of legitimacy. Because we hear a lot about even the legitimacy of the ICC being claimed to be anti-African, being not focused outside of Europe or the West, etc. We would hear that definitely a few European states, for example, decided to create a tribunal over crime of aggression happening anywhere in the world. Anywhere in the world, we would hear those arguments too. So once again, theoretically possible, the immunities could be solved, but I'm not sure if that would be the best path to you know, continue. Rather, the amendment of the Rome Statute would be the solution, because why create two when we can change one, when we speak theoretically. The other, and please tell me if I'm abusing my time allocation, because I forgot to follow the time. Okay, so another pathway obviously is, thank you, is to create an ad hoc tribunal by the United Nations Security Council, as it happened in the case of the IC2I and the ICTR, which were measures not involving use of armed force. But of course, if there is an interest involved of any permanent member of the United Nations Security Council, that's not going to happen. There is another path, though, agreement between the UN, sanctioned by, not sanctioned, verified by the United Nations Security Council with the territorial state. The same problem I just said. So immunities solved, legitimacy very likely solved, because it would be an act of the United Nations. Nonetheless, the likelihoods is not high in any case. So the last one that I see as the most possible, the most likely, and the most, well, that's not a good word, the most solvable, to solve the question, so to say, how to solve the problem before the ICC gets changed accordingly, because that I still see as the best path, simply to amend the ICC. But till that happens, I'm looking for other paths. Until that happens, I think that the best way would be, if there actually is any act of aggression, that needs to be looked at whether it also fulfills in connection with other elements the crime of aggression. Then the territorial state would do the best actually to make a deal with the United Nations that the UNGA would then approve. It would not be the first time in the world. It happened in the matter of the extraordinary chambers of courts of Cambodia, for example. And that, however, is not a completely international tribunal. It applies to domestic law. So it's obviously conditioned by the fact that domestic law of the state in question is amended in a way that allows for such prosecution. But I'm looking at it from the point of view of international, and if it was so, then that state would actually exercise its own domestic jurisdiction, however, with the help of the international community, where through the act of the UNGA, assuming that it would approve it, then the question of legitimacy would be solved, because it would be act of representative of the entire international community. It could help also possible financial problems. But of course, it will not be, as I'm writing here, a coercive mechanism. It would rather be legitimacy. It still, though, however, has problems. It's not something that would solve every possible issue. One of the questions is what I'm writing here as the first thing: before or after conflict? Well, the ICC is so far the only tribunal that was, or court, that has been created even before conflicts create. With the ad hoc happened, with the ad hoc tribunals, it's always been after. And imagine that the victim state that would like to cooperate with the UNGA, for example, or with the Secretary General and get it approved by the UNGA, would in fact lose at the end of the conflict. I'm not talking about a particular situation. So I'm just theorizing. That would, of course, change the attitude. So we need to think about this before any conflict ends, of course, whether we pursue those paths or not. Another issue that I have mentioned is enforcement, and something that needs to be kept in mind also, trial in absentia, because that is a matter, you know, if we do not, if the aggressive state does not get doesn't lose completely, it will likely not surrender its representatives or the individuals that would be accused of committing not just aggression, obviously, but any crime under international, unless they're caught outside of their state. So, of course, can we try in absentia? Well, international law is not completely sure about that. And even if it would be, or even if it was sure, it would not really help legitimacy in such a trial. So should we need to think about it. I'm not saying yes or no, I'm just saying we need to think whether we should create a tribunal now, when it could take years to be active in it. And of course, finances would definitely be an issue. So maybe, well, I'm not arguing against the ad hoc tribunal, I'm just arguing in general. I'm saying that maybe before the conflicts are over, we should, of course, collect evidence, especially when it comes to crimes under international law. So maybe till then, an investigative mechanism, see whether we are ready to create an ad hoc tribunal and, you know, go step by step. So I was trying to show the advantages as well as disadvantages, rather than saying something is good or bad, because that's obvious. Every situation needs a different solution, which was one of the reasons why I didn't want to look particularly at one case. But I hope I kind of suggested some thinking about these topics, and I thank you for your attention, and sorry for skipping from one topic to the other, because it's quite a wide topic. Thank you. I stop sharing.
Okay, thank you very much, Milan, for this very nice overview of the possible options. Let me tell you, when you were talking about the possibility to the United Nations General Assembly, I had this kind of feeling, which I do have for a long time now, watching the activities of the General Assembly related to this question. I do have this kind of feeling that maybe slowly we are seeing United for Peace resolution being revolved or revived or something. Just looking at how the political things are and the tendencies are moving in the General Assembly among the member states, it had kind of like an idea in my mind, or at least something that I was really starting to be a little bit afraid of, that maybe the General Assembly would try to revive the United for Peace resolution and do something based on that, because of our possible Russian constant veto in the Security Council. But well, we are going to see how it's going to happen and go on. And thank you very much for showing us a very nice overview about these possibilities. And then the next one who would have the floor, according to the plans that we have, is Evhen, Professor Tsybulenko, who would like to address Basically, two questions. One is the question of genocide, and then the next question is to some extent connected to the question which was covered by Milan, the possibility of a new criminal tribunal related strictly to the question of aggression. So Evhen, you would have the floor.
Thank you, Tamás. Esteemed colleagues, dear friends, I'm really happy to be here and to see some of my old friends. Actually, yes, the original my idea was indeed to talk about creation of new tribunal for major Russian criminals. But as Tomás informed me, Milan was planned to present more or less the same. I decided to concentrate on the genocide issue, but still I have probably some remarks as to the tribunal. First of all, thank you, Milan, for such extensive and very interesting overview of theoretical possibilities. But my idea was exactly to talk about practical possibilities, how to actually punish major Russian criminals. And actually it was inspired, of course, by several pretty landmarking events. Like, first of all, it was open statement of the prominent politicians as well as prominent legal scholars. And the first signature was actually former Prime Minister of United Kingdom, Gordon Brown, with the actually idea to create the special tribunal for the crime of aggression as to the Russian criminals. Later it was, as all of you know, was supported by PASE in its resolution, and also there was pretty interesting conference in Vilnius, which ended by famous Vilnius communique. And question is how it basically should look like. Well, Milan explained very well why ICC is pretty helpless as to the crime of aggression. And that is clear that probably the only one possibility, practical one, to create a new ad hoc tribunal. Indeed, question is how to do it. As it was also explained, it's impossible to do in the way as it was done with former Yugoslavia and Rwanda tribunal, because with Russian Security Council, it's absolutely impossible. That's why we believe that probably it would be a possibility to organize a special court using more or less model of court for Sierra Leone or for Kosovo. So basically it could be either international treaty or it could be within auspices of another international European organizations. And also question is, should it be only for the crime of aggression or basically all international crimes? Actually, currently we have more discussions about specific tribunal for crime of aggression, but I think it's a bit unlogical, because if it will be specifically for major Russian criminals, I can hardly imagine the situation that they will be judged for aggression in one tribunal and for genocide, for example, in another tribunal. Simply illogical. So I think that a tribunal which will be specifically focused on the major criminals should have jurisdiction over all 4 crimes. But of course, it should not be alone. It should work in close cooperation with ICC, with Ukrainian national courts. So basically, crimes which could be punished by Ukrainian courts could be punished respectively by Ukrainian courts. But if state is unable because of the problems with legislation, which Justinas mentioned, or if it's unable because criminals are hiding themselves in Russia, well, International Criminal Court can intervene. But as International Criminal Court is unable to punish the crime of aggression, so for a major Russian criminals, we'll have specific tribunal which will tackle only with major criminals. Basically, same was with Nuremberg in Germany, because, well, it's a pretty well-known fact for specialists, but not the for the common people, that Nuremberg was not the only one tribunal in Germany after the Second World War. There was actually hundreds of other tribunals which judge minor criminals. So Nuremberg was specifically for the major criminals. So it could be exactly the same story. We'll have tribunal for major criminals, which will be ad hoc one, and we can have ICC, which will tackle with other criminals, and also national Ukrainian tribunals could also punish people who are in the hands of Ukrainian justice authorities. So that was the remarks as to the tribunal. Of course, we can discuss it during the discussion more in detail. Now let's talk about genocide itself. Actually, I'm not going to tell you about the well-known facts about the definition. So we have the definition by the Genocide Convention. As also Justinas mentioned already, Ukrainian legislation is pretty similar to this classical approach. What is important, of course, that we have 5 specific forms of genocide, basically a physical element, but it's important to connect them to the general part of the definition, which is a mental element. And it's the most important and problematic issue, because we need not simply to prove that there are killings of the members of the group or causing serious bodily or mental harm whatsoever. We should always prove that there was an intent to destroy a certain group. So as we remember, there are 4 groups which are mentioned in the conventions: national, ethnic, racial, or religious group. And if we're talking about Ukraine specifically, we're definitely talking about national group, because Russian genocide is not targeted, I believe, to the Ukrainians as an ethnical group, but specifically as a Ukrainian, as a political group, because regardless of their ethnical origin, if person believes that he is a national of Ukrainian, he or she will be targeted by the Russian Federation. And of course, to prove such an intent, it's always the most problematic issue. But I can say that in that sense, they're probably lucky, because our enemies are not very clever, let's say. And if usually people try to kind of hide their intents, Russia, vice versa, they openly advocate the intents. Actually, all of us probably know about statements of Putin in the beginning of open invasion. And he basically denies the right to the existence of Ukraine, claiming it's a kind of historical curious or something like that. Same was mentioned by Medvedev, who is currently deputy head of the Security Council of Russian Federation, but for several years he was the president placekeeper for Putin, as you also remember. So he's pretty high official in Russian Federation. But probably the most evident was the article which was published in RIA Novosti by Timofey Sergeytsev. I will actually put to the chat the link for an official translation of this article. So it's there, which could be translated as what should Russia do with Ukraine? And this article is a clear and open manifest of genocide, I believe, of the intent to destroy Ukrainians as a nation. Of course, it tries to present the situation as this mysterious denazification of Ukraine, and also de-Europeization, which is openly stated in the article. So basically, they equalize of denazification and de-Europeization of Ukraine, which already shows that this notion of denazification of Ukraine is absurd as such, because it's a pretty well-known fact that Ukraine has one of the lowest in Europe level of not even Nazism, but even nationalism. So if we will look the composition of Verkhovная Rada of Ukraine, which is Ukrainian parliament, we will see that any single nationalistic party is not representative in there. Like, I don't know, Le Pen party in France, or Alternative for Germany in Germany. So there is no such parties in Ukraine. There are such parties in Ukraine, but they never, at least during the current parliament, they have not passed the 5% barrier. So usually their support is kind of 1.5–2% maximum. So basically, to talk about denazification of Ukraine, it's complete nonsense. I'm not talking about the fact that Ukraine also had the lowest level of anti-Semitism in Europe. It's also proven fact, which is proven not only by statistic, but by the reality, because as you probably all know, current president of Ukraine has Jewish origin. And if we will look to the previous president, Poroshenko, his prime minister, Groisman, he was also Jewish origin. And if we will look to the Ukrainian government in general, we will see it's a mixture of all possible nationalities. That's why exactly they're talking about not ethnical, but actually national group, Ukrainians by all ethnic origins, because you can find people of absolutely different nationalities in Ukrainian government. It was even such an internet meme, what is basically Ukrainian nationalism. Then Armenian and Georgian in Russian language discuss who are the bigger Ukrainian patriot. That's happened then. There was a kind of verbal fight between Saakashvili, who was former president of Georgia, but on the certain stage he was also the head of Odessa regional government, and Avakov, who was Minister of Internal Affairs of Ukraine, and he was Armenian by origin. So it shows basically absolute diversity of the Ukrainian government. So basically nationalism, I'm not talking about Nazism, is absolutely typical kind of notion for Ukrainians at all. But when they're talking this article, we should understand that then they're talking about denazification, they're talking about de-Ukrainization. So it's absolutely clear from the article, from all their statements, so basically everything which has Ukrainian mentality presented as a kind of Nazis. Respectively, then you're reading that article, just change Nazism to Ukrainian. And then this article will show specifically all intents of Russians which would like to destroy anything which related anyhow to Ukrainian mentality. We would like to make simply kind of another part of Russians. Generally, it's a general idea of Russians that Ukrainians never existed, that it's a kind of part of Russian people, which was specifically kind of created by Austrian general staff during the First World War by Lenin. As Putin said, actually all this historical rubbish, but important is that it's used as an official statements. And if we will come back to that article, so basically, it directly says openly, you can check it yourself by the link, that Bandera elite must be eliminated because of its re-education is impossible. Just must be eliminated, full stop. And the rest must survive the hardship of the war and get the experience as a historical lessons and atonement of its guilt. So basically, of course, again, if we're talking about this Bandera elite in the sense of understanding of Russians, again, it's everything which is related to Ukrainians. But what is important to say that, as I have mentioned, it was published in the RIA Novosti, which is state-owned media. And we should clearly understand that there is no any freedom of speech in Russian Federation. So basically everything which is published in the state media is censored many times. So we can be sure that if such things was published in RIA Novosti, it's clearly something which is not simply opinion of the writer, but it's a clearly position of the state. Furthermore, there was a pretty big scandal after the publishing of this article, but it was not denounced by anybody in Russia. Furthermore, Medvedev, a couple of days later, basically almost repeated all main positions in his statement, which were mentioned in that article. So we can say that we can see the intent to destroy national Ukrainian group very clearly. And coming back to the specific forms, so killing of the members of the group, it's clear, as well as the causing of serious bodily and mental harm. I think all you know about all those facts. Only important point to mention that they simply do not know the number of killed persons, because all those evaluations presented by UN or by other organizations basically figures from the territories which are under Ukrainian control. We could not see what are happening under the in the occupied areas. And according to some evaluation, only in Mariupol probably more people were killed than all these figures which are presented by UN, in particular non-occupied territories. But I would like to pay also your attention to the third form of genocide, deliberately inflicting of the group conditions of life calculated to bring about its physical destruction of whole and apart. So basically, it's also clearly from Russian actions, because as you know, Russia deliberately destroy critical infrastructure in Ukraine. It destroys hospitals deliberately. It destroys schools, it destroys museums, it destroys basically water supplies, electricity. Time of the beginning of war, it was still basically winter and it was very cold. They destroyed the heating systems. So basically, and again, stressing that very often it's happened deliberately. Like probably the most well-known cases happened in Mariupol. Then maternity hospital was bombed, as well as city theater, which was used as a bomb shelter. But it's only a few examples, but such things happens across the entire Ukraine. And if we're talking about destroyed hospitals, schools, it's counted already by hundreds. And it clearly shows that they definitely would like to create situation, then it will be simply impossible to survive. Simply the losses for infrastructure, let me tell you exact figures. So it's more than $270 billion. It's a direct losses, and specifically in infrastructure, it's $120 billion. And if we will talk also indirect losses, it's already $565 billion. So you can see how significant is actually the destruction of everything in Ukraine. But also, of course, one of the most appealing facts, which Tamás mentioned already, is transfer of the children to the Russian territory. And actually, we should keep in mind that it started not even now, it started already in 2014, because we should also keep in mind that war is ongoing already for 9th year. So in this February, we have only new phase of the full-scale Russian invasion, but war itself started with the occupation of Crimea. And actually, the fact of the kidnapping children started also in 2014. Furthermore, the cases filed by Ukraine in European Court on Human Rights, famous case Ukraine versus Russia #2. So basically, it was about the abducting of 3 groups of Ukrainian orphans, children, to Russia. But now, after the full-scale invasion, yes, it's actually now it's absolutely astonishing figures. Indeed, more than 200,000 children were deported, some of them with parents, but also a lot of orphan children were deported to Russia. And a week ago, Putin published an order which simplified providing of Russian citizenship to such children, which makes it absolutely clear that then we will receive Russian citizenship and will be raised in Russian orphanages. We will be completely brainwashed, and we can be 200% sure that we will lose any Ukrainian mentality. Furthermore, they will be not even neutral to Ukraine, but we will be raised as like it was an Ottoman Empire, famous Janitsars. You probably remember it from history. The children were taken by Ottoman Empire and they were raised, and in the end they became the elite guard of Ottoman Empire with 4 children. So it will be exactly the same story. And actually, probably to finalize my speech, I would like briefly mention some historical points, because this position of Russia is not something new. Probably all of you know that in 1933 there was famous Holodomor. Then, with different evaluation, from 4 to 12 million people were slaughtered by artificial starvation by Soviet Union. But point is that Dr. Raphael Lemkin, who, as you I'm sure know, was a lawyer who actually coining the term of genocide and was one of the initiators of Genocide Convention. That's why I believe his opinion is probably most professional as to the genocide in general. He believed that Ukrainian genocide by Soviet Union was much broader. He believed that it was at least 4 elements, and Holodomor as such was only one of them. So he believed that first stage was the killing of intelligentsia in Ukraine, which was kind of destroying of national brain, as he said, to paralyze the rest of the body. The second was the attacking on the Ukrainian church, priests, other religious hierarchy, killing the soul of Ukraine, and only the third one was exactly the Holodomor as such, targeting first of all farmers, who was a large mass of independent peasants, and they were kind of keepers of all tradition, folklore, music, whatsoever, national language. There was already the killing of the body of the nation, as we said already, by starvation, probably the most horrible way. And also he said that was also fourth stage, it was assimilation of Ukrainians, bringing people from the other territories. So it's well known that in the houses which were emptied by the diet because of starvation people, they brought people from Russia to go to those houses, and also disperse Ukrainians, deportations to Siberia, etc. So, and all those 4 elements committed the Ukrainian genocide by Soviet Union. So basically Putin goes fully in accordance to continue the genocide which was started by the Russian Federation. So actually, of course, I clearly understand that international scholars are pretty accurate to believe that it's specifically genocide. It's clearly crimes against humanity, because there is no doubt about the fact that it's systematic and widespread, because currently it's already more than, I think, just a second, well, more than 15,000 war crimes which were officially registered by the Office of the General Procurator. And of course, majority of them, of course, there are some war crimes targeted to prisoners of war, etc., but majority of them are specifically targeted against civilians. So that's why we can talk about widespread and systematic attacks against civilian population. And again, according to the General Procurator, every day 200-300 crimes committed additionally. So it clearly shows that we can talk without any doubts about crimes against humanity. But just the genocide, yeah, as I said, there are some skepticism still. That's why some political moves are very important. So already several countries made political statements, and Estonia was actually the first one which Parliament Regi Kogu adopted statement recognizing Ukrainian genocide. Same happened in Latvia, in Poland, and some other states. Of course, it's a political statements, but I think it can push certain legal activities as well. So that more or less it which I was planned to say. Thank you for your attention, and I will be clearly ready and happy to answer questions and participate in further discussion.
Thank you very much, Professor Tsybulenko. Let me tell you that you have not really made me happier than I was earlier with your intervention. Thank you very much for giving us your opinion on the matter, and I'm afraid I have to say that yes, there is a growing consensus, I believe, among our professional ranks and also in the public opinion about thinking about the current events rather as being genocide as well. Yeah, so it's really the situation is really dire. So thank you very much for showing us all these additional information that we did not necessarily know, and your analysis on the matter. And then we would jump to Beatrice from Bucharest, who is also a long friend of ours. And I would like to give the floor to you if if you are ready for taking it. So thank you. Would you mind switching on your microphone?
Yes, I'm fine. It's okay. Thank you very much, Tamás. I'm very glad to see a lot of friends participating in this meeting, and I'm also happy to make new friends, friends of IGL or friends of international criminal justice. I think it is very important to have the to organize the floor for addressing all these measures, which actually all these expressions of I would say juridical expressions of and analysis of the situation. I would like to present this evening something which is from the perspective of everything what was said until now, but looking at the measure of impunity for international crimes. While impunity became, let's say, on the lips of everybody during these days and from the starting point of aggression against Ukraine. So my presentation, although is not going to be a written one, so I didn't prepare any slides, because I did not have the time for doing it. We'll focus on this new measuring of the impunity for international crimes. Ukraine scene of crimes is like, you know, like in a policier, like in a the movies with detectives. But unfortunately, we are in a situation in which Ukraine became the scene of the international crimes, and it's important that we try to understand how impunity should be put to an end in this situation. Impunity, as everybody knows, means non-punishment, and the traditional causes for this impunity refers to usually to the lack of involvement of the national courts or to the absence, inapplicability, or non-functioning of the existing judiciary mechanism. Although they are not new and they are well settled, this traditional causes applies also in the situation of Ukraine. What actually I think it's important to understand from the point of view of putting an end to the impunity for the international crimes committed in Ukraine is the way this actually conflict, international conflict, as already described by my previous by the previous speaker, is the way this conflict was advertised, because we are actually assisting to a strong advertisement of the Russian aggression against Ukraine. From day 1 to day 100, we do have a very close follow-up of all the criminal activities, international criminal activities, which are actually unrolling on the Ukrainian territory. Just to remind, from a reminder of these events, I would refer, for example, the nuclear threat which was put by President Putin on February 27. We do have on 16th of March Mariupol theater raised. We do have the horrors in Bucha documented, and we found out about all these events as they happen, as we speak, as we brief on April 2nd and 3rd. On April 8th, we do have acknowledged the rocket attack on a train station in the eastern city of Kramatorsk, which killed at least 57 civilians. And there is the examples could actually go further. What makes this armed conflict so special from the point of view of the crimes committed is that we do have knowledge and documentation of the international crimes in the real time. This is why Ukraine becomes a real scene of crime, like in the movies of the detectives, as we witness digital evidence of war crimes in Ukraine as being collected, verified, and preserved with the help of international organizations. We do have direct involvement of the Ukrainian government to crowdsource and corroborate evidence of the alleged war crimes. For example, I think many of us are familiar with different applications. For example, application which allows the citizen, the Ukrainian citizen, to document damage to their homes using facial recognition software to identify Russian military officials in photos, and new tools to guide users through the process of geotagging or timestamping their footage. I mean, we are really assisting to a very advanced technology documentation of the crimes and the international crimes committed in Ukraine. And I think it's very important to note that also we are witnessing an unprecedented use of open source information as evidence in the case of Ukraine. Now, this also helped the reaction or improve the reaction of the public. And I'm talking about public in general, I mean, from ordinary people to politicians, to discuss the impunity, the putting an end to the impunity in case of Ukraine. I think it is very important to note also this effervescence of media, which was ready and willing to publicize all the reactions of the politicians in relationship with the most juicy perspective to put Putin on trial. I would just quote from some of the articles which were published on media. For example, as it is the article written by Dominic Cassiani, what is war crime and could be Putin prosecutor over Ukraine, which I think it's very interesting. Very interesting article of the BBC News published on 5th of April 2022, which makes or acknowledges all the statements of US President, the UK Prime Minister, who both accuse Russia of carrying out war crimes in Ukraine. We do have the publishing of Joe Biden on 4th of April on Twitter, when he speaks about Putin, and he says this guy is brutal. What's happening in Bucha is outrageous, and everyone's seeing it. So it's a call to the fact that it is a public eye, and I'm talking about the international public eye, looking at what's happening, and everybody knows and everybody acknowledges the war crimes which are committed. I also would like to quote the Human Rights Watch approach and the text published on building war crimes case against Vladimir Putin, published on 27th April 2002, which is also a very interesting and clear statement in regards of the war crimes committed by Mr. Putin, as they put it in the article in Ukraine. I will be very happy to share all these links with you, but I'm sure that you, or I hope that actually you already read them. What is very interesting in this human rights statement is that it gives a clear insight on the fact that the crimes committed by Russia, by Putin, are analyzed by international organizations. Human Rights Watch states that Human Rights Watch analyzed who bear, for example, command responsibility for war crimes in Syria province, and that they reached they determined that command responsibility for these apparent war crimes went all the way to the top, to the Russian President Vladimir Putin, and they are also say that they analyze now the Russian war crimes, which also appear to be committed by Putin in Ukraine. There is also other kind of media approach in which it's the authors published try to show that there is a change in the landscape of the global justice. I would quote an article which was published on May 10th, where it's written that now, however, an unusually large group of states is actively assisting investigation into atrocities in Ukraine, which many expect will eventually lead to the ICC to indict Putin. The intensity, sorry? Hello?
Yes, it was just a technicality, nothing.
Okay, the intensity of this investigation is greater than anything I have seen in nearly 3 decades of work in the fields of international justice. So the conclusion is that the landscape of the global justice is changing with warp speed, and the convergence of several key factors in Ukraine has fueled this shift. And this article ends, it's really good with the involvement of the readers to vote against or for the conviction of Putin. And the question is, it's a live counter. Do you think Putin will be convicted for war crimes? Till now, 4,000 people voted on this matter, and I think it's a very interesting reaction of the readers. I assume that all the readers are also educated readers who actually voted for the conviction actually voted for the belief that Putin will be convicted. Now, I also wanted to spend very little time on existing judicial mechanisms for ending impunity for international crimes in Ukraine. I don't want to repeat what the previous speaker said, but just as a very short view on this existing judicial mechanism, I would say that we do have the national Russian and Ukrainian courts, which could, and Ukrainian courts also try to put on trial those responsible for committing crimes, international crimes in Ukraine. We do have the universal jurisdiction, which allows any country to prosecute those hostis humani generis, enemies of the entire humankind, and we are in the situation where those responsible for these crimes could be prosecuted by any country anywhere in the world, theoretical or not. And we also have the possibility to set up an ad hoc criminal tribunal, but we saw how difficult this issue could be and how much it depends on the politics. And we also have ICC, you know, the hated and very debated ICC, which until now was considered to be only the court for the Black continent. If we are discussing in terms of ICC, I think it's important to remind that triggering ICC jurisdiction according to Article 13 of the statutes could be done proprio motu investigation by the ICC prosecutor. The second possibility provided by Article 13 is the deferral of the situation by the Security Council of the UN, and third, a deferral of a situation by a state. Well, also as a very quick reminder, I think it's important to see when a preliminary examination could be actually open. According to Article 53.1, letter A to C from the Rome Statute, preliminary examination could be open at the deferral of a state or of the Security Council, based on the information transmitted by physical person, group, states, and intergovernmental or non-governmental organization, or based on a declaration of acceptance of the jurisdiction of the court. Of course, there is an entire process to follow up this preliminary examination, because it is a due process in which it has to be determined the jurisdiction of the court, the admissibility, and the interest of justice for ICC to actually open further an investigation. Based on this, on the information which are verified by ICC, the Office of the Prosecutor decides which is the reasonable basis for opening an investigation. Well, we all know that Ukraine is not the first, let's say, preliminary examination by ICC. We do have the preliminary examination opened in 2014, which was triggered based on the statements of Ukraine to accept the jurisdiction of the court from April 2014 over the crimes which are committed on its territory between 21st of November and 22nd of February 2014, and after from September 2015 over the crimes committed after 20th of February 2014. So we do have a preliminary examination, but we also know that actually the preliminary examination was closed 6 years after its opening in 2022, when actually the Office of the Prosecutor decided and concluded that an investigation could be opened as the situation was deferred, which was deferred, actually fulfills the criteria. In regards of opening the investigation, only on 28 February 2022, the prosecutor, the chief prosecutor of ICC, Karim Khan, announced that it decided it's ready to open an investigation of the situation in Ukraine. So 28th of February, 4 days after the after Russia invaded Ukraine. But based on the preliminary examination, which started in 2014 and was finalized in 2020. On 1st of March, the Office of the Prosecutor also received on 1st of March and later on 2nd of March and 11th of March. And I'm also very happy to note that also Romania was among the countries which deferred the situation happening in Ukraine to ICC. In total, 43 states deferred the actual situation in Ukraine to ICC. But I think it's important to note in regards of this matter, which will actually lead to the new measuring of the impunity for international crimes, is that ICC does not trial in absentia, which makes very difficult the role of ICC in following all this investigation. It can be a very useful exercise, but it is very difficult to foresee how the investigation open, even closed, with sending to trial of Putin and all his collaborators will actually happen. In present, there are 31 cases which are already decided or still on the pending with the court, out of which 11 cases are still in the pre-trial phase because the accused could not have been brought in front of the court. Everybody remembers Omar al-Bashir, Mahmoud Mustafa Abu Saif, and others of this kind. Now, impunity actually is treated expressly in the statute of ICC, and in the preamble, it is expressly written that the states party to the statutes of Rome are determined to put an end to the impunity of the authors of international crimes and to cooperate for the prevention of new crimes. Now, how this will happen is very difficult to foresee, as I already said. But what I think it's important to try to see as a conclusion for this new measure of impunity for international crimes, which is set in this Ukraine case, is that there are different factors which actually measure impunity, as in the famous legend of the Provost bed. I don't know whether you are familiar with the Provost bed. Provost bed, you know, the Provost, the thief and a criminal who was actually trying to burglar the the people traveling from Athens or to Athens, and as a mean of torture, he would put them in a, depending on their height, on a small or a long bed, and if their legs were actually too long, the legs were cut. If the legs were too short, they will be elongated till death. So I think that what we are witnessing now in regards of the impunity for international crimes is this kind of Provost bed, in which many factors should be considered, among which the fragility of the international public law as a cooperation law, instead of being a law of ordering of subordination, the domination of the political interest. And I think here it's very important what actually the international community is willing to accept a peace negotiated with Putin, because at this point there is no one to negotiate the peace, a peace negotiated with Putin. And how can you negotiate a peace with Putin if you follow the interests of international criminal justice and want to bring Putin to trial. We also have to consider the non-functionality of the collective security system, also the limits of the judicial mechanism existing or to be created, the geopolitical division between different groups of countries, and I think also it should not overlook the attractivity of the negative hero or of the rogue state, which actually is quite an example followed, unfortunately, by many countries, many big countries, many big states, big in size at least, and also in power and population lately. So it is not something we are really able to foresee at this moment, and impunity still remains under the crocus bed to be fit or not. Thank you, Tamás.
Thank you very much for this very nice overview of all these issues that you have brought in. And then, as the last speaker of this evening, it's my time at this point. First of all, I would like to start with saying a warm thank you very much for taking my invitation and giving us all your opinions and view on this matter. When you look at the program, you may find the title, it's going with the flow or turning the tide. Basically, one of the interesting questions for me when starting to think about this event is, it was basically to spend a little time thinking about the role of Europe, the role of European institutions, which is closely related to my current job here in Brussels as well. And of course, my love for international humanitarian law, which is to somewhat related to this. But when this conflict has become an open aggression, I have really started to think a lot about the possible European reaction to this, because I believe that what happened and what is going on is basically happening, and it's going on right in the near closure of our European integration, which is a unique phenomenon of international relations, where I do believe that all of us and all of these countries and this political community is believing on what for simplicity we can call the European values, but that includes a lot of things which are clearly and openly are being violated currently now because of the Russian invasion. And I believe that what is happening is not only a test to international law, international humanitarian law, but at the same time, it's also a very important test for humanity of Europe, for the humanity of our community, of our political and legal community as well. And one of the very interesting things to see, and thank you very much again for giving us, for bringing in all these very important experience and knowledge about how the international legal and institutional framework is holding up in the current situation. Of course, I believe nobody had the illusion, neither myself, that the European institutions are going to be able to turn the tide in the war that is going on the territory of Ukraine. But I did not expect either that they would, like the European Union and some of the European institutions, that they would just go with the flow and do not have any effect on the current ongoing situations. Now, I wanted to take a good look on various European institutions. I'm going to cut it to a little shorter because of the time that is, as usual, is cruel to us. Of course, I wanted to talk a little bit about all of the relevant European institutions, including the Council of Europe and the possibility and the role of the Strasbourg Court, the European Court of Human Rights. By taking the membership in the Council of Europe, of course, Ukraine has taken an obligation and it has expressed its will to belong to the European community, which community now should definitely not turn the back on Ukraine. And at the same time now, when Russia started to communicate about leaving the Council of Europe, I'm sorry to say that obviously and probably Russia has also sent us a very strong message about what it wants and what it doesn't want to do in the future. I believe that losing Russia from the Council of Europe is one of the biggest loss that the whole European political community has to endeavor and has to somehow work it out. There was, of course, so that the lawyer is also here, there is also an open question, at least in my mind, about Russia leaving the Council of Europe as such. Was it completely in conformity with the founding statute of the Council of Europe? I have some doubts about it. I mean, Russia has indicated that it wants to leave. On the other hand, the Commission of Ministers have made it clear that they are going to remove Russia from the Council of Europe. I could go into this issue, but I don't want to. If it was fully in conformity with the statute of the Council of Europe or not, the Council of Europe statute requires that the Commission of Ministers communicates toward the given state that it should be thinking about leaving itself. Now, this communication has never been done. So, according to my opinion, Russia is leaving the Council of Europe. It is not excluded from the Council of Europe. Of course, when we are talking about the effect of this, it could not make any difference to some extent. But I do believe that this step from Russia, at one point, shows the strength, one of the strengths of the European institutions, including in this case, the Strasbourg Court, that the Strasbourg Court has always been kind of like a problem to Russia, to President Putin. We could see the legislative process within Russia about giving these extra possibilities to the Russian Constitutional Court, etc., which slowly but surely made just a mockery of the whole process, unfortunately. So to some extent, we could argue that leaving the Council of Europe is at least a clear situation. When we are going to come to the European Union, I believe that one of the most important experience, and now I start with the easy, the simple experience, is what the presentation of Agnieszka have already drawn our attention to, that it's very important that the European Union is giving all the support that is needed for the civilian, for the non-governmental organizations, for all those non-governmental entities that work for giving a easier situation, help the situation currently with refugees coming from Ukraine. But at the same time, there are the hard and the troubling questions with the European Union that I believe that these states have to face, and the European Union as a community, as a political community, has to face. And that comes together with some of the burning questions of the possible future of the European Union as well, namely, what kind of European Union do we envisage? What kind of European Union do we want to have in the future? And these questions have always been on the table through the past few years, but now on the questions of how to react to the current war, what to do, how to build up a sanctions policy against Russia, I believe that these fault lines have unfortunately very clearly being shown. Like, for example, the debate related to sanctions. And now at this point, of course, it hurts me to say that my government's activities and actions are basically one of the issues that everybody knows about. But these questions are related to the future of the European Union, about the decision-making process, about what kind of organization, what kind of entity the European Union member states want to maintain in the upcoming few years. I believe now that this war has clearly showed to these European Union member states that the current decision-making process as such, if they wish to uphold it, it's not going to make the European Union an entity, an organization which is going to be able to react to these kind of situations in the way like many would require or many would like to. Many Europeans would like to see the European Union being able to react to these cases, these situations with more swift and quicker action, but the current decision-making process on this matter doesn't make it possible. And of course, I don't want to make decisions about it. I have my own opinion about what I think to be the best for the European Union, just as I believe everybody here does have. But these questions, I mean, the current war in Ukraine and the need to react to it by the European Union has amplified these questions and showed us even more painfully how these questions need to be addressed and handled. While on the other hand, what makes me a bit happy to see is that some of the policies of the European Union, some of the questions which have been not really subject to debate, luckily, during the past decade in the European Union, for example, support to the International Criminal Court, it makes me a bit happy to see that this kind of policy position has not changed. And obviously, the support towards the International Criminal Court is still there. Hungary was one of the countries who have supported the referral of the situation of Ukraine to the International Criminal Court. Even I say this, even if I feel a little bit in discomfort because of this, because by analyzing the ICC statute, I'm not going to go into that detail. I will have it for another event with some other international lawyer colleagues. But to be honest with you, I'm a little bit feeling a bit discomfort by the idea of a state party to the ICC statute is referring a situation of another state to the International Criminal Court, especially when at the same time the given state has already made a declaration accepting jurisdiction of the ICC earlier. I believe that the office of the prosecutor has made this step only to circumvene the pre-trial process by the court, which should be applicable in the case of a proprio motu proceeding. And I don't think that this is in conformity with the statute itself. But once again, this is the lawyer looking for mistakes and problems all the time, while in reality, of course, I'm very happy. And I do believe that the International Criminal Court shall have the chance, and of course it does have the chance, to check, to make sure that, to try to do what it can against impunity in the current war. So I do believe that continuing with these policies by the European Union is extremely important. I believe that the long-term support for the International Criminal Court is paying off. At this time, it's very important that the European Union shall be continuing with those kind of policy buildings and developments and everything. While on the other hand, the hard question should not try to avoid it again. The hard question is really that the European Union has to make decisions, and the even harder question maybe is what to do with Ukraine and the possible EU membership of Ukraine, which of course in the heat of a war and urged by the need to help and assist with political actors, you may have opinions, you may hear opinions about the support of the membership of Ukraine to the European Union. But as we all know, unfortunately, because we are not 4-year-old kids, we all know that the political reality of turning Ukraine a member state of the European Union is not going to take place only because of the Russian aggression. While it, of course, gives a lot of political support to this issue, and it's no question, but that question of accepting Ukraine as a member of the European Union, we all know that it's not subject to these moral values, but there are a lot of everyday political interests coming into that picture. And I believe that is going to be probably one of the even more painful questions and problems that the European Union itself and the member states of the European Union has to make an agreement about. And as we know that, as we can see that, the member states of the European Union may be very vocal on nice values and principles when we talk about politics, but when the push comes to the shove, they don't necessarily walk the walk while they like to talk the talk, of course. So I believe that these questions are still ahead of us. Thank you very much for being here. In the meantime, I was checking if there were any questions from the audience, but there were some very nice supporting comments, but no questions. And basically, as we have run off the time, I would definitely not like to keep you away from your families any longer in this nice evening. So thank you very much once again for joining our event here. As I written you, but I'm going to send all of you an email with all the rest that will come. I would like to have the recording of this video uploaded into our YouTube channel, but I'm also very much happy to send your presentations video recording to you if you want to use it as well. I'm going to write you all of this in an email, and possibly if you have the tendency, or if you are interested in that, maybe we could also talk about or think about a possible publication on this. I'm talking to my guys about it here, but that is all I believe that is still ahead of us. The options may be opened. I'm going to send you an email about the possibilities. So thank you very much for showing up. It was very nice for me personally as well to see all of you again after a long time, shorter, longer time. It was very nice meeting you, Agnieszka. Thank you very much for accepting our invitation and my invitation. And I hope that as probably the COVID is going to go away, or at least I dare to hope, then we will have the chance of personally meeting each other again, just like pre-COVID times. And of course, I also wish that we should have some more delightful subjects as well and reasons to meet, not only this tragic situation. So thank you very much for showing up. Let me just express all my gratitude for you and all my sympathies to the people of Ukraine and everybody who feels affected by this tragic war that is going on that territory. Let's hope that it's going to end at one point. Thank you very much for being here. It was nice meeting you again, and hope to see you soon. And I'm going to cut the live broadcast at this point. Thank you very much.